the spirit that we try to capture in our programming. It would be almost too narrow to call most of these panels bipartisan, because we believe that each one of these speakers brings a unique perspective, really, to each of the tensions that we hope that they will explore in their panels. The subject matter is somewhat encapsulated artistically in the title as the new Leviathan, re-examining the expansion of federal power. And essentially the premise that we started from as we came up with this topic is the idea that when the federal power expands, it doesn't do so into a vacuum. Rather, it enters into and perhaps encroaches upon other spheres of our life, namely local government, such as state government or municipal government, and perhaps even more sacred territory of individual rights. And so we have dedicated 3 panels to various tensions that we believe has been created by this. Our first is the Religious Liberty panel, which will start very shortly. And in addition, we are very delighted to have Professor Hadley Arkus here providing a keynote address, which I'm very much looking forward to, and we're very thankful for Professor Arkus for being here and the James Wilson Institute. Just a couple of thank yous are in order, and then one technical matter, and then we will get started. Thank yous first and foremost go to all of the speakers who are willing to make a tremendous sacrifice of time to be here and to join us in this project, including behind me and above me, and Professor Arkus. We are just so delighted and truly honored that you were able to come today and be here for this. Secondly, we have to thank all our partners who helped us to get the word out. They are listed in sort of colorful display on the back. Each and every one of them contributed. The John Jay Institute and all the fellows who came. Always happy to see you guys. You're not here enough, really. That's probably our fault. We need to invite more. James Wilson Institute, as I mentioned, the National Constitution Center, the Collegium Institute, the Intercollegiate Studies Institute, and Yards Brewery, actually, has become a great partner for us. And you will see the fruits of that friendship at the reception.
Is that in a speaker bag as well?
Yeah, look forward to that. And then finally, I just wanted to thank my board, some of whom are here, who worked tirelessly, and I know that because I saw it myself, to put this together. It's really been an honor to work with you guys. All your work is just, it's just fantastic, so thank you. Okay, finally, maintenance. We have Wi-Fi access for this event. There are sheets of paper that have instructions, and I would ask that if you have used those instructions or are not interested in Wi-Fi, that you would just pass those sheets around so that everyone can get access. You'll be signed on to the Penn Law Wi-Fi as a guest, so we'll provide it for you today.
Yeah, thank you, Rob, for organizing this.
Okay, without further ado, I think I'll have Professor Bibas start us, and hope you enjoy the day. And if you have any questions or need any concerns, please don't hesitate to ask me or any of the speakers. Thank you.
Thank you, Rob, and welcome. I'm Stephanos, a professor of law and criminology here at Penn. I'm delighted to welcome you to the first panel, The Future of Religious Liberty in the Shadow of Obamacare. In previous generations, religious liberty, free exercise type claims and related free speech claims haven't been as complicated. The size of the government was much smaller, and when you look at earlier generations, the conflicts, whether they be under the free exercise or free speech clause, involve things like having to recite the Pledge of Allegiance in West Virginia Board of Education versus Barnett, or exemptions from the military. But when the government's domain is smaller, the potential conflict with the negative liberty, the right to be let alone, is less. As the size of the government has grown, as its extent has grown, and as people have started to conceptualize legislation as creating positive rights to health care, there's much more potential for clashes in rights or supposed rights. This came to a head a year ago in the Hobby Lobby case, and the panel won't just be about Hobby Lobby, but it's at least a jumping off point for us to discuss. Hobby Lobby was technically a statutory construction case, though the statute was designed to implement a particular vision of free free exercise that the Supreme Court itself had backed away from under the free exercise clause of the First Amendment. So the statutory interpretation of the Religious Freedom Restoration Act was whether the government was justified in this particular case in overriding religious liberties. And the court, in a 5-4 divided and strongly argued decision on both sides, ruled that closely held corporations can't be forced to pay for all of their employees' contraceptives if doing so would violate their religious beliefs. And that ruling didn't stop the debate. If anything, it's continued the debate, and people who sided with the dissent have worried about its being broader or extended. Those in the majority read it as a narrower just reaffirmation of what should have been a more settled issue of law. But these kinds of conflicts are likely to continue, and there are strong views, feelings, and legal arguments on both sides, and I'm delighted that we have an eminently well-qualified panel to help us understand what the issues are, where they're going, what we can expect to see in the future, and at the state level, and as these debates play out beyond the Hobby Lobby case. And so let me introduce to you the 4 distinguished panelists that we have here today. To my right, and speaking first, is Ilya Shapiro, a senior fellow in constitutional studies at the Cato Institute and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, Ilya was a special assistant advisor to the multinational force in Iraq on rule of law issues. He practiced at Patton Boggs and Cleary Gottlieb, and he's published widely on religious liberty and public policy in a range of journals. He holds his bachelor's from Princeton, a master's from London School of Economics, and a JD from the University of Chicago Law School. After Mr. Shapiro, we'll have Professor Robert Field to his right, who holds a joint appointment in health management and policy at Drexel University. He's also a lecturer in healthcare management at the Wharton School here at Penn, and a senior fellow at our Institute of Health Economics. He's published extensively on healthcare policy and regulation, and formerly founded and chaired the Department of Health Policy and Public Health at the University of the Sciences here. He earned his JD from Columbia Law School, where he was associate editor on the Columbia Journal of Environmental Law. With us remotely, because of injury but unbowed, is Jordan Lorence, the indefatigable senior counsel at the Alliance Defending Freedom in Washington. He's litigated many First Amendment cases around the nation over the past 3 decades. He argued the Southworth case before the U.S. Supreme Court, has appeared on many television and radio shows. He holds his bachelor's from Stanford University and a JD from the University of Minnesota Law School. And finally, to my far right is my colleague Sally Gordan, who's a widely recognized church-state scholar. She's written books on the Mormon question and polygamy, and now The Spirit of the Law, Religious Voices in the Constitution in Modern America, and is currently at work on a book about religion and property in American national history, a fascinating project that you all ought to await. She co-edits Studies in Legal History and is on the board of the Cromwell Foundation and the McDowell-Hartman Foundations. She's received teaching awards here. She's a distinguished lecturer, and I can say personally I'm very proud to have her as an invaluable colleague, as well as a wonderful marathoner. She's the Arlen M. Adams Professor of Constitutional Law and Professor of History here at Penn. She holds her BA from Vassar, her JD from Yale, her Master's in Religion from Yale, and a PhD in History from Princeton. Please join me in welcoming our wonderful panel. We're going to try to have the panelists keep their opening remarks not too long, 8-10 minutes each from their microphones. Then I'll have a little bit of back and forth among the panelists here. After that, I'm going to try to throw it to the floor for questions. Each of you here has a microphone in front of you. You have to press a button on that microphone, and the green light goes on. That means that, in fact, we can hear you. So I'll call on people after we do a little back and forth with the panel, and we'll wrap up by 11:40. So first, Ilya.
Thank you so much, Stephanos, for that introduction, and to the Federalist Society for inviting me to come out here with such an august panel, including the head of Burwell here behind me. So the new Leviathan, right? Meet the new Leviathan, same as the old Leviathan, right? I'm a generalist. I don't just cover religious liberty. I just don't just cover health care. I sort of cover whenever a big kind of meaty legal constitutional issue comes to the fore in public affairs. That's my job, to feign expertise on that. And this case has really, and its consequences has really drawn me in. Even though I'm not at all religious, even though I don't really, I'm not subject to the contraceptive mandate myself, and Cato's insurance, health insurance has certainly changed because of Obamacare. Most notably, we've had to decrease the number of intern slots and the amount of time we can give to internships because of the way that Obamacare operates. But I'm not here because have some sort of deep personal connection to religious practice as it relates to contraception or something like that. And that, I think, I hope makes me more of an objective observer, because this is indicative of a larger phenomenon, what I've coined as hobby lobbification, whereby regulations and mandates increasingly squeeze out civil society. I have an article of that name coming out in National Affairs next month. Because this case is the tip of the iceberg. It's about how corporations can fire women who use birth control, and that religion trumps all other values in constitutional discourse, right? Or at least that's what my Twitter feed told me. As we all know, those of you who have by this time, I think, have had some time to actually read the case and understand what it's about, know that it has nothing to do with the power of big business or the freedom to use any legal contraceptive or how to balance religious liberty against any other constitutional consideration. As Stephanos described, this was a rather straightforward question of statutory interpretation about whether the government was justified in this particular circumstance in overriding religious liberty. And the court ruled that closely held corporations can't be forced to pay for all of their employees' contraceptives. That's the way that the Religious Freedom Restoration Act is meant to operate, on a case-by-case basis, look at whether there's a substantial burden on religion and whether the government can justify that burden, whether it has a compelling reason for pursuing its activity that burdens religion, and there's no other ways of achieving that. And the government didn't show, because it couldn't show, that there was no less burdensome way, no way that didn't force people to violate their religious conscience or pay millions of dollars to achieve the same goal. The government could have free clinics, it could have tax credits, a whole host of other less burdensome ways. And this wasn't because the Religious Freedom Restoration Act was imposed as some sort of Christian conservative scheme to overturn foundationally understood holdings on the nature of rights and relationship of citizens to government and so forth. This is a law that passed unanimously in the House and 97-3 in the Senate, and called them religious zealots, but the lead sponsors were Chuck Schumer in the House and Ted Kennedy in the Senate, signed by President Clinton. I guess responding to that great secular humanist, Antonin Scalia, right, that in Employment Division versus Smith. So, there's so much misunderstandings about this case, and also about this parade of horribles that might happen in the future. All of a sudden, are people going to be denied blood transfusions and, who knows what, right? Or, McDonald's is no longer going to serve gay people. Just bizarre extensions that RFRA does not implicate in the least, because, again, RFRA causes case-by-case adjudication involving substantial burden, compelling interest, and narrowly tailored, all of these ultra-legalistic phraseologies that actually matter. We can talk about those if you want. What I think, though, is more interesting is, what really, I think, is the focus of the panel, not just rehashing and debating Hobby Lobby on the merits and, whether RFRA should be amended or not, but the larger lessons here, and that's that the essence of freedom is that government can't willy-nilly force people to do things that violate their consciences. And Obamacare is such an unprecedented statute, well, for many reasons, but one of which is the way that it insinuates itself into people's lives in so many different ways, violating a host of statutory, constitutional, and natural rights. While the focus of the contraceptive mandate cases is the intersection maybe of corporate rights and religious liberties, there's a bigger issue. It's the latest example of the difficulty in turning over health care or increasingly our economy more broadly over to the government. Because when something is socialized or treated as a public utility, we're forced to fight for every carve-out of liberty. The more that the government controls, whether we're talking health care, education, even marriage, the greater the battles over conflicting values. It wasn't the founders of Hobby Lobby here who created this conflict by changing their policy to oppress women. It was the government that came in and told them, oh, it's great that you provide health care for your people, now you have to provide all this other stuff. And that's what created the conflict here. With certain things like public goods, national defense, basic infrastructure, we largely agree inside reasonable margins, but we have vast disagreements about social programs, economic regulations, and so much else that the government now dominates at the expense of individual liberty. And so that's why I would love for us to have an omnibus Freedom Restoration Act, or really a constitutional amendment that just puts at the end of every phrase in the Constitution, and we mean it. Because then you wouldn't have this expansive government power, which is the real problem. It's not about asserting government religious liberties, individual, corporate, or otherwise. It's about checking the Leviathan that creates these values conflicts. And so those who supported Hobby Lobby before the Supreme Court are rightly concerned that people are being forced to do what their religious beliefs prohibit. But this is all part and parcel. This all comes with the collectivized territory. Thanks.
Okay, so I'd like to sort of do the opposite, start broad and then narrow it down to Hobby Lobby. And I'm going to key off themes in a book of mine that appeared about a year ago from Oxford University Press entitled Mother of Invention, How the Government Created Free Market Healthcare, with the phrase free market in quotes. The title obviously meant to attract attention from groups like the Federalist Society, maybe the Cato Institute. And what it really focuses on is the definition of a public good. You describe national defense. I would say that many of the things that we call social programs are actually public goods when it comes to creating our healthcare system. The government has grown and become more complex. Healthcare has certainly grown and become more complex. I think orders of magnitude more complex in terms of the trajectory than the rate at which the government has grown. Just think of healthcare today, gene therapy, organ transplants, as opposed to healthcare 50 years ago. So I look at what I consider to be the public goods on which our healthcare system, and in particular what we call the private end of it, rests. The National Institutes of Health funds basic biomedical research. You could not have the applied research that creates drugs without that. You can talk to any senior executive in any drug company, and they will tell you that they wouldn't exist, or they certainly wouldn't exist in their present form if it were not for the NIH. It's a public good in the sense that it benefits us all, and yet a private entity could not do it on the same scale because you can't charge for it. Most of it would not be patentable. It would be difficult to keep as a trade secret, and it's very speculative. You don't know whether the basic research will produce anything. So that's why the government steps in, and as a result, we have the Human Genome Project and personalized medicine and statins and on and on. I do a lot of case studies of examples in the book. Medicare we think of as a social program for the elderly, and yet our hospital system couldn't exist without it. Before Medicare, about 50% of the elderly did not have health insurance. It's likely that if it weren't for Medicare in some form, at least 50% wouldn't be able to get it, probably more because healthcare is so much more complicated and expensive and difficult for an insurer to afford today. Most hospitals rely for about 40 to 50% of their revenue on Medicare. So many would go out of business, if not most. The equipment that they have, the procedures that they perform, the outpatient clinics, all of that exists because of Medicare, not to mention whole industries like renal dialysis and home care and hospice care and outpatient radiology. It also funds medical education. There are few, if any, doctors in the United States whose training was not funded by Medicare. Their postgraduate training in hospitals. That's a public good. We need doctors to be trained, and yet it's hard to imagine a private entity being able to spend money on that. And Medicaid we think of as a social program for the poor, which it is, but it's also the financial foundation for pediatrics in this country. Pediatric hospitals rely on Medicaid for a huge proportion of their revenue. CHOP down the road would not be in, it might be in business because it existed before Medicaid, but it would not be doing gene therapy and be one of the world's most preeminent referral centers if Medicaid didn't exist. Not to mention the safety net hospitals, which rely on Medicaid for a huge portion of their revenue, and again, no private entity could insure poor people who can't afford the premiums. Having said that, however, there is an inherent conflict when the government gets involved in anything between protecting public health, promoting private sector health, and individual liberties. Public health in particular, look at quarantine. Look at what happened during the height of the Ebola epidemic. We talked about taking people off of airplanes and denying them all of their liberty for a period of time. You couldn't have a clearer conflict than that. There was a feeling that the protection of the public trumped the individual liberty to be free of what amounted to incarceration. Vaccines amount to the same thing, and we see that right now with the measles epidemic. Most states have exemptions for religious objections to vaccines. 2 states do not, West Virginia and Mississippi. Guess what? Mississippi has the highest rate of vaccination in the country and has not had a new measles case since 1992. So there's a balance, but there's a general feeling that when lives are at stake, as they are with an infectious disease like measles, public health and the government's responsibility to provide for the common good can triumph. When we have an issue like providing contraceptives or certain contraceptives for women, it becomes, I think, more difficult. How important is the government's interest, and how do you balance that against people's objections? I will put aside, for the moment, the issue of standing in corporate personhood, which raises a whole other host of questions as to whether the Greens truly were forced to violate their religious beliefs or whether they are separate persons than the corporation they created. But what concerns me about the Hobby Lobby decision is that on the one hand, the justices said, oh, this is very narrow. It just applies to this one set of contraceptives. And yet they articulated no limiting principles. So in the future, there's no way to know what the limits would be. I agree that cases like this are case-by-case determination, very fact-sensitive. But case-by-case doesn't mean ad hoc. It doesn't mean whatever the judge's personal religious convictions are should rule. It's case-by-case based on legal principles. So how do you differentiate these contraceptives from blood transfusions, vaccines, organ transplants, antibiotics, anything else that someone might want to prevent coverage for? Well, it would be nice to have some guidance on that. And in the absence of guidance, the field is wide open. There's really no basis to distinguish, no principle on which to distinguish, other than a statement in the opinion, dictum at best, that, oh, we're only talking about contraceptives here. This was the Supreme Court's chance to articulate a principle, to articulate the line, and they didn't do it. They didn't even acknowledge that there was a line to be drawn. The deference to religious belief, I would say there's a difference between your ideology, your morals, your philosophy, and your view of actual medical facts. And there is considerable dispute in the medical community as to whether the contraceptives that they do not want to cover actually interfere with the implantation of a fertilized embryo or actually prevent fertilization. They chose to believe that it prevents implantation in contradiction of most medical opinion. Do you accept any belief? Do you accept a belief that says evolution didn't happen, the earth is not round, the earth is older than 5,000 years? are no factual beliefs subject to challenge, I would wonder about that. And then getting back to the standing issue, the court said this applies to closely held corporations only. Based on what? Where does it say that in the law? And it said because there's unanimity, what if there isn't? What if a cousin of the Greens joins them and votes to cover contraceptives? Do you go 80%, 50%, 90%, 100%? Where is the legal principle there? Again, potentially it could apply to every corporation because the court does not, even though it had the chance, explain that. So what I worry about is we have a decision that is based on the personal religious beliefs of the justices hearing the case, and if that is not a threat to religious liberty, I don't know what is. So we do have a difficult balance. We have to have the government involved in public health and healthcare, or we wouldn't have a healthcare system. But it would be nice to have some clearer guidelines as to where the Supreme Court thinks that balance should be.
Jordan Lorence.
Thank you. I feel like I'm looking at the faculty here, the panel, and I feel like that Apple computer ad from the Super Bowl in 1984. So I hope nobody, no woman runs in and throws something at the screen here about what I'm going to say. And I am not there because I slipped and fell here, get in front of the camera, and broke my wrist about a month ago. And 2 days ago, the doctor said it's not setting up right, and we have to operate and set your bones. And so I'm just recovering from surgery, which then gives me the plausible deniability, since this is about healthcare. If I say anything stupid, it's the Percocet that did it. It's not me. So I'll just, in advance, blame that on the drugs with all of this. I had some things to say, but I feel like I wanted to respond to the last speaker. I was one of the attorneys for Conestoga Wood Specialties, the other case that was connected with Hobby Lobby, and just say a few things about this. But I do agree, and I just want people to see that when government expands, this is when you have these conflicts. So, for example, 40, 50 years ago, when the Vietnam War was on, there was a military draft. There was a lot of conflict by religious pacifists challenging those laws. Now, we don't have a draft now, so those conflicts disappear. Now, I'm not saying government should, we just shrink government and these all go away, but I think that that is something that's got to be identified, that the growth of government produces this. And Obamacare, there was, as Ilya said earlier, there just was no dispute before Obamacare came along. Now, one of the things that I want to, that I feel when we're in these debates, that I just want to identify up front is that I think many people deal with the legal doctrines this way. Well, if I was in those person's shoe, I wouldn't do what they're doing. I think their belief, I don't understand it, or I think it's ridiculous, or I just think it's wrong. So therefore, and I think this is a non sequitur, they should be denied their religious liberties. And I just want to say that everybody benefits from religious liberty protection. So, for example, I've been trying to think of examples of that aren't, like right-wing Christian type things that to demonstrate this. So, for example, I found a case from 1972 in which a high school in this case went to the Sixth Circuit, a high school in Memphis said, everybody, in order to graduate, you either have to take a physical fitness class or pass the ROTC course. And one high school had no physical fitness class. All they had was ROTC. So a student who had religious beliefs against war, was a pacifist, said, I cannot in good conscience take this. And they said, fine, you don't get to graduate from high school. And Tom Clark, who was at that time a retired justice from the Supreme Court, wrote an opinion. He was sitting on the panel and basically said, really, you can't make some accommodation here? This is just ridiculous. And they ruled in favor of the student. And so I just bring this up because normally the conservatives aren't, pacifist, just to demonstrate that these religious liberty issues apply across the board to all people. Now, I just want to make a couple of comments about what was said earlier, is that the corporations issue, when the Washington Post was trying to be enjoined by a prior restraint from publishing the Pentagon Papers that Daniel Ellsworth found. It was brought by the Washington Post Corporation, and nobody said corporations lack freedom of press rights. And I just think that the corporate entities having First Amendment rights is not some bizarre concoction by the Green family or by the Hahn family, but is something that we accept in many other contexts. And you know, we don't say, Microsoft and Google and Twitter, you are subjected to warrantless searches because you're corporations or something like that. So I just think that that the arguments that were brought against Hobby Lobby and Conestoga would never be brought in other contexts. They would just be rejected out of hand. Then the other thing that I would bring up about this is that I feel that the government created this, especially the Obama administration. The legislation passed by Congress for the Affordable Care Act does not contain the HHS mandate. It is a creation, and there are things that are mandated, that existing plans, even if you're grandfathered, must include certain things like the 26, cover children up to 26-year-old until they're 26 years old, et cetera, which many of you may be benefiting right now from, that sort of thing. But this was a creation by administrative regulation, and I feel they went out of their way to add this. Now, what the Supreme Court said, and this is where we just haven't seen this, blood transfusions and, people being denied cancer care or whatever, that sort of thing, is because nobody has religious beliefs against them, and nobody's going to bring lawsuits. But I think the Obama administration should have anticipated that they were going to have this problem. And then the Supreme Court basically said there are there's a huge percentage of women employees that are basically excused from the mandate. That if your corporation is 50 employees or fewer, no HHS mandate. All those women are denied coverage by the government, not by the beliefs of the employer. And also, grandfathered plans don't have to do this if they. And there's a little more complexity to that. But that amounts to, the Supreme Court said, tens of millions of women employed who are not covered by this. And although this was not the basis of the decision, they said that there was a least restrictive means by private, to nonprofit religious groups were getting a way to opt out of this. I just think that there's sort of this is a compelling governmental interest when you set up the rules so tens of millions of women don't get access to this. And there, as Ilya said, there's other ways to do this. And I just want to say this, if the government, we have to say that the government, at least to some extent, has to protect conscience, because sooner or later, the government will do something you don't like. They will impose something on you, and the cupboard of constitutional arguments will be bare if we say, no right of conscience, no religious liberty, no freedom against compelled speech, those types of things. We've got to guard against those. Thank you.
Professor.
Thank you. Yes, sorry. Thanks, Stephanos. Thank you, everybody. I have to start out by saying that Jordan is a hero. I've had a broken wrist. It's no picnic. And it's great to see you there, even on the cold screen, and I promise not to throw something. I did want to agree with Jordan about the long-standing acceptance of the rights of corporations. In my own research, I have found that the first general incorporation statutes were for religious organizations in the 1780s and 90s. This goes way, way back. And in many cases, religious organizations were not allowed to take, say, by bequest unless they were incorporated. So there's not just a relationship, but almost a mandatory relationship between religious organizations and corporations. So I'd like to have Jordan's back on that. On Hobby Lobby, I do think it was an underdeveloped case. I mean, there just wasn't a full record. On the other hand, I think it was a very difficult stance for the government to defend not only were, by definition, very small employers exempted, but nonprofits had already been exempted as well. And the attempt to draw the line in the sand between profit and not-for-profit was hard work, I think, for the government. It was hard work for the dissent. It's strained. It's in some ways unattractive. On the other hand, I thought the majority's emphasis on closely held as the magic quality is also strained and hard to defend. So I'm not sure I think anybody got it quite right, and I think that may in part be related to the underdeveloped quality of the case itself. I did want to think a little bit of how complex it is to think about expanding federal power and the relationship between growing national and perhaps growing state power. It's really complicated, in part because not only did RFRA get some teeth in the Hobby Lobby case, but many states have their own religious freedom restoration acts. In fact, several had them before the federal statute, and the federal statute is in some ways a copycat. So there's big RFRA and baby RFRAs. And it's clear that Hobby Lobby gives all RFRAs more power, potentially, both state and federal. So the relationship between local and national government here is complicated. And the politics following Hobby Lobby have also been complicated. And I'm thinking here of several proposed amendments to state RFRAs that would exempt religious actors from claims of discrimination should they, say, refuse service to clients based on their religious convictions. This waft of proposals, only one of which has been enacted and was vetoed by the Arizona governor, but this waft of proposals clearly is trying to carve out some space, especially after the Supreme Court agreed to decide the same-sex marriage question. Supporters of such statutes are motivated by the desire to protect the photographers, the bakers. We're all familiar with that small-ish line of cases, and to analogize them in that sense to the closely held corporations in the Hobby Lobby case. The problem with these proposed amendments to RFRAs is that they are not limited in which kinds of discrimination they protect, not just sexual orientation, but of course other kinds of discrimination, race, gender, national origin, are included, and arguably religion, right, are included under this umbrella. And it tees up a problem that we've met before, and that was very messy in resolution, and yet I think most people in the room would agree was decided the right way. The old Bob Jones case, remember Bob Jones? Yes, the old Bob Jones case pitted the IRS against a sincerely held religious belief in the sinfulness of the mixing of the races. The case wound its way up to the Supreme Court and produced an 8-1 opinion in favor, holding race more dear to the Constitution than religion. And the opinion was both attacked and defended. But society has changed. Honestly, we do not want, and Bob Jones has changed. It says we regret our segregationist past. It really has abandoned that position. What these poorly drafted statutes do, and I think do without perhaps thinking it through, is that they tee up a similar problem. And so the politics following Hobby Lobby, I think, are untoward in many ways, and some people are galloping down a road that they probably shouldn't be galloping down, and this is happening in several states, most recently Georgia. And one of the things that I think makes this so complicated is that we've become so bitterly divided in a partisan way that we're not really thinking sensibly about the kind of legal fallout that we should make from an opinion that does seem to hold religion and the rights of corporations to religious freedom in some sensible ways. And what I think we need to guard against is having it become just a bitter, name-calling, partisan divide following on from that. Thank you.
All right, so let me give each of the panelists a minute or two if he wants to respond to one or two things that have just been said, and then we'll open it up for questions. Ilya, do you have any?
I want to pick up on this, the very last point about poorly drafted statutes. Some of them definitely have been. I think the Kansas mini RFRA or updated RFRA was particularly kind of mealy-mouthed, wasn't even clear from a draftsmanship perspective, let alone in terms of the merits. But some of them were fine, I thought. I thought Arizona's was fine. I got some media coverage because I wrote a blog post saying for marriage equality, for religious liberty, and I had no problem with Arizona's mini RFRA. A lot of states have mini RFRAs, by the way, because, for example, a lot of these parade of horribles are simply inapt. If you accept the appropriateness of anti-discrimination laws in a private setting, we'll sort of cabin and set aside the libertarian objection to regulating how exactly private businesses conduct their business and choices they make and who to hire and et cetera. But if you accept those sorts of laws and public accommodation laws, then religious objections to a law saying, you know, you can't discriminate based on sexual orientation or race or religion or gender or anything has to fail, because there is no less restrictive means of achieving the compelling interest of preventing discrimination in hiring or serving someone based on these protected classes than in prohibiting such discrimination. You can't have, as an alternative, the government providing a tax credit or the government providing a clinic or any of these sorts of things. In a lot of these parades of horribles, they would fail. And, you know, we can talk separately about the merit, as I said, what I cabined, the public accommodation laws, employment discrimination laws, what have you. But on their face, if all we're talking about is the brave new world of mandates and religious objections there too, it's not really a brave new world. And as to transplants and transfusions and all these things, look, RFRA's been around for 30 years. We would have seen a whole host of objections by lots of different people if this really was a problem. And the only sorts of objections we've really seen are individual defendants in marijuana cases saying you shouldn't prosecute me because I'm part of the Church of Marijuana and things like this, which courts read through because the only thing they look at is whether your so-called religion is pretextual for the litigation or whether it's a sincerely held belief. And so, you know, that's why this problem really is overblown, and that's why I think it's perfectly legitimate that as government grows, the response is, well, if we can't constrain government, then we need to fight more and more for carve-outs. And it shouldn't just be religion. It should be for all sorts of things. If you're an employer who wants to give other types of health care to your employees, or not provide health care to your employees, but give them greater salary so they can buy it, that is illegal now under Obamacare, and that's a problem too.
All right. Okay, so my opening remarks responded largely to Ilya. I want to respond to some of the things that Gordan said. With regard to corporations and constitutional rights, when you look at the Washington Post, that involves freedom of the press, which is specifically mentioned in the First Amendment. That is actually the only industry that's mentioned specifically in the Constitution.
Press is an activity, not an industry.
Well, we can, maybe it's both, but that is whether it's an activity or an industry, it is specifically addressed in the Constitution in the context of freedom, and the others are not so specifically addressed. With regard to search and seizure and so forth, I think you also have to look at common sense. A corporation has property that can be searched or seized. A corporation does not have individual beliefs. Individual beliefs belong to individuals with nervous systems and brains and feelings and so forth. So I think there's a distinction there based basically on common sense. With regard to the blood transfusions, there are religious groups that object to blood transfusions. There are religious groups that object to organ transplants because they believe that involves stopping a beating heart, which is the equivalent of killing someone. With regard to the issue of corporations with fewer than 50 employees, actually the same rules do apply to those people. If one of those corporations has a health insurance plan, then it would have to abide by the same rules. So we're only talking about the plans, the companies that don't have plans. Again, if you get your insurance from an employer with fewer than 50 workers, this would still apply. And for the others, you would have to get your coverage some other way, presumably through one of the exchanges, and those plans are subject to these rules. So there really is no carve-out for those people. RFRA has been around, yes, for quite a while. The concept of mandating coverage for contraceptives is hardly new. 26 states mandated that coverage before Obamacare, and in fact, Hobby Lobby at least had no problem in providing the coverage up until 2012. I think what made them flip, and I don't know whether they changed their sincerely held beliefs or what happened, was the attention to Obamacare. And I think because of that attention, you're more likely to have companies like Hobby Lobby suddenly deciding, we've been doing this, but now the federal government forces us to do it. Let's take a closer look at this. Maybe we don't want to cover blood transfusions because we're Jehovah's Witnesses or organ transplants or whatever else. And again, I would say it would have been awfully nice if the Supreme Court had given us some guidance on that in the Hobby Lobby decision.
Corporations don't have beliefs. And it just seems when I go into Starbucks and they're proudly announcing how they do free trade or fair trade coffee, and some clothing company will say, we pay fair wages, etc., on our own accord, not under duress from some international agreement or whatever, to make sure that the factories in Bangladesh are safe and the workers are paid well, etc. It just seems like we applaud these things, or some corporation that takes extra precautions to cut down on pollution or its carbon footprint. We say, wow, there is a corporation with a conscience. And so I just think it is odd to say corporations don't have beliefs, people do. Well, that's true, but corporations are a mere legal form for people to operate through. It's for liability purposes and things like that. And so to say a company, can't take communion or have a bar mitzvah, it also, then what do we make about fair trade and all this sorts of stuff? So I think we want business owners to operate with a sense of moral conscience. And when the government expands, we should not be surprised when these kinds of things come in. Now, I would just add to this, we mentioned, I did the Elaine photography case in New Mexico, that I would just add to this, that when we see these laws expanding, these non-discrimination laws, to cover expressive activities, then people have problems. The religious beliefs in all of these cases that I'm aware of are not, we don't serve gay people. I'm not aware of any of them ever saying that. It's that we don't want to be forced to make a message we don't agree with. And maybe one of the things that cabins these arguments is forced participation in ceremonies that they don't agree with, or forcing them to make messages they don't agree with. These are more free speech rather than free exercise, but I think that there is something to this, that if you compel people to do something against their will, I'm thinking that there's many businesses that are for profit that are clearly expressive oriented. I mean, we mentioned the Washington Post, for example, but you think about things like advertising agencies or website designers or even tattoo artists. They don't dispense a uniform product. So the analogy is not to the segregated lunch counter. A customer comes in, they say, I want a website or an ad campaign or a video made. Well, what do you want to have in it? What do you want it to be about? And you can imagine scenarios of where somebody would say, I in good conscience just cannot do that. What I think is interesting, this is a real story. You can Google this later about Antonio Darden. He is a hairdresser in Santa Fe who used to do the hair of Governor Susana Martinez. And then he said, because of her stand on same-sex marriage, I no longer in good conscience can do her hair. And he was lauded by the Huffington Post and other ads. Now, people have responded, well, that's not a particularized, there's nothing in a non-discrimination law that says, you can't refuse service because of somebody's political beliefs. Well, Seattle, District of Columbia, Puerto Rico, political affiliation and beliefs are all classes that are prohibited. But nonetheless,
I've always wondered how there's all these think tanks in D.C. because by definition we discriminate on ideology when we hire
right.
people.
No, I think that's right. And the thing that I would point out is here is somebody having a conscientious objection to doing the hair of the governor, which is not promoting an ideology, and yet people see no problem and say, what a man of conscience. And in fact, the Huffington Post article about this talked about how waiters in wait staff in restaurants said, when the governor comes in, we're going to refuse to serve her because of her stand on same-sex marriage. And I think, what is more like a segregated lunch counter? That or what Elaine Photography did in her case?
Thank you. That's really interesting. Yes, I entirely agree. These statutes seem to be aimed at the artisanal but public consumer business, and the question is, do we want to allow them to discriminate? And if we agree that discrimination, if the barber refused to cut her hair because she was African American, that would be unacceptable, then we have to be much more careful about how we're drawing these lines. I take your points, Jordan, and I also take the sincerity of the cases. It's clear, but I don't think that makes it easy. That's all I'm going to say.
All right, happy to take questions. When I call on you, please press the button so the green light comes on, and then identify yourself by name and, if you want, institution, so we know who you are. Yes. There, please, go ahead.
I think you have to hold it, apparently. No, I reintroduced, rehabilitated, in the words of David Bernstein, so that we recognize all of our rights and we reverse, Caroline products and the bifurcation of our rights, so we have certain second-class rights, as well as reversing Wickard and the modern, regulatory state and all that. So, for example, state mandates for vaccination I have no problem with, but a federal one outside of some really bizarre alien-related circumstances. I can't imagine. So, yeah, the problem that you run into is, of course, that if you take away RFRA, then which was responding to Employment Division versus Smith, the Scalia opinion from 1990 that I alluded to, which I think was probably correct. I don't think you can have courts just reading in exemptions willy-nilly. If you want an exemption, go to the legislature. But there was that 30-year interregnum where we had judicial religious exemptions. But as I was saying, and to come back to the original premise of your point, the problem is, government doesn't have the power to interfere with our rights of varying kinds in the first place. But if we're not going to observe those internal constraints, then we need the external constraints of things like RFRA.
Other comments? Please, somebody. I'm going to start calling on our students. All right, push your button, please, and identify yourself. Hold it down.
The majority didn't say that it interferes with implantation. They said that the plaintiffs were allowed to believe that without question, that if they accepted that as fact, there could be no inquiry beyond that. So were there an inquiry, perhaps there would be a division in medical opinion. The preponderance is that it doesn't, but there may be dissenting views on that. But my point is that they state a belief related to a scientific fact, and that is beyond question. And I'm asking, I'm making a distinction between factual beliefs and moral, conscious, religious, philosophical beliefs, and saying that factual belief, I find it odd that no factual belief can be questioned if it's couched in religious doctrine.
Let me ask a moderator's prerogative question, which is, one of the concerns that critics of Hobby Lobby have had is this issue of attenuation. When we have the military exemption cases, you have a pacifist who says, I won't work in the munitions factory, but I don't have a problem working in a steel factory, even if the steel is going to munitions later. So for those who think Hobby Lobby was rightly decided, do the courts just basically take whatever the objector says, which I take to be Professor Field's point? And for those who think Hobby Lobby might not be rightly decided, well, are we going to have the courts developing the equivalent of the Catholic doctrine of double effect or other things? Are the courts in a position to talk about, develop a religious doctrine of foreseeability or proximate cause here? Whichever way you go, we've got problems here. So let me hear from the people who are more favorable towards Hobby Lobby, and then maybe from the people more skeptical about how one deals with these very awkward questions of how entangled a religious belief is with a particular action, because everything has ripple effects at some point.
Gordan, you want to start
I can
off?
start here, the big guy on the screen. I do think attenuation is an issue that could come up, and that I could conceive of a case where the religious believer's connection to what he or she finds offensive is so remote that there you would just say there's not a violation there. The one thing that I would add to this is that what I think has been a bigger actual problem in this litigation, that I've been involved, types of religious liberty litigation, is the courts second guessing the beliefs and saying there's a way that you could avoid this. Like, now, this wasn't said in this case, but, well, Hobby Lobby, you could just, sell all your stores, or, you could, move to Bolivia or something like that. Now, those are fanciful ones, but I've had things where it's basically, unless the religious adherent takes every step possible to avoid connection, so they're basically cornered. There's nothing else they can do. Then they get religious liberty, and I think that that's been more of a problem with case law than the attenuation issue.
Could I jump in? Yeah, just because I don't know if I'm entirely favorable or entirely opposed. I think the opinion is moderately successful. The question, though, really is one that courts have ducked and ducked again and again and again. They have not created a definition of religion. They have not created a definition of what counts as conscience. They haven't done any of the sort of groundwork that would make deciding what was too attenuated or not something they could actually engage with. They've taken refuge in sincerity. If a belief is sincerely held, and it's a very low bar, right, and may have no connection to the actual effects of something. But I don't think this is a problem unique to this case. I think this is a much bigger issue. I'm not sure we would do any better if we did have sensible definitions. Doug Laycock, a very interesting and intelligent advocate and law professor in this field, once said, once you start talking about what religion is, you're literally in a religious space, and you can't talk yourself out of it. So I think it's really interesting that what we find so admirable about this country is the vibrancy, the creativity, the changeability of religious life. We just can't seem to nail down how we want to treat it in law.
Which is why I think it's admirable that courts always, since time immemorial, American courts have stayed away from becoming theological courts and making judgments like you alluded to. I've debated this case many times, and one time it came up, the Greens' beliefs can't be sincere because Hobby Lobby buys some of its products from China, and of course in China they have forced abortions. And it's kind of like, at a certain point, a butterfly flaps its wings and causes a tsunami, and everything's connected to everything else. So, there's, everything is too attenuated, or nothing is, I guess. But, there it's not even that Hobby Lobby was trading with the government of China, which is, pursuing these policies, and even if it was, you're not responsible for all the bad things that your transactional partner is doing. But it's, Chinese companies, and are they involved in? So it's at a certain point, it's the knee bone's connected to the shin bone, and rather than a court stepping in and saying 5 degrees separation in Catholic doctrine is too attenuated, but in Protestant doctrine it's actually 3 degrees. They just stay out of it and say, look, you're paying for an abortifacient, you think, and therefore we'll just take that as at face value and apply the rest of the rubric.
If I can just point out, this is an interesting tension that goes way back in America. Realize some of the earliest settlers to come to America came so that they could have their distinctive religious colonies. They were dissenters fleeing the official Church of England. And then, so we have this, there's often residential segregation, even in cases like Curious Yoel, people move somewhere to be amongst themselves. And, America's pluralism and diversity has many strengths.
Curious Yoel is the kosher version of Curious George, is that?
A pluribus unum, out of many one, but at the same time there's this issue that we expect to tolerate one another in the marketplace with a thin set of connections as Americans, but there are thicker connections within religious communities, and the more that more aspects of our lives are brought into to rub up against one another, the more likelihood that differing religious beliefs that now vary very much from person to person and not just denomination or church to church are going to come into conflict. So it's an interesting issue that is one the colonists 400 years ago would not have faced. Okay, push your button, Craig.
I just wanted to speak to the attenuation. And first of all, to your point, I think that's the public health controversy right there. The common good depends on things like vaccines and various public goods, and it's going to conflict. With the attenuation, there's a distinction here. One is paying for insurance that includes the contraceptive coverage. The other is paying a salary that enables the employee to go out and buy it on their own. Companies have to pay minimum wage. If someone uses that minimum wage to go out and buy these products, is that different from the company facilitating it through the insurance?
Obviously, yes.
Well, I think that's the question.
Okay, Craig, push your button and introduce yourself. Hold it down.
That's not what I said, but anyway, go on. Preventing discrimination than prohibiting discrimination, right? Sure. Can I answer that one before I forget? First of all, any of you who are going to be plaintiffs' lawyers, make sure to sign up Little Sisters of the Poor as your lead plaintiff for whatever type of case you're bringing. Just great PR. So, I mean, you have to treat RFRA on its face. And just to underline my point about public accommodations law or employment discrimination law, if the state compelling government interest is preventing people from not being hired or having adverse employment decisions made against them for an improper reason, there is no less restrictive means of achieving that state interest than to prohibit employers from discriminating for that reason. Whereas in Hobby Lobby, the government could have achieved the same goal by paying for it, by providing tax credits, by X, Y, Z. Little Sisters of the Poor, you were talking about the nonprofit, still corporate, so, again, it's not the corporate non-corporate, it's profit nonprofit at this point, which, query why do nonprofits have different rights than for-profits. You can have a completely for-profit kosher butcher or halal butcher or Christian bookstore, as one of the co-plaintiffs was here. And they objected not just to the direct payment for purchase of these emergency contraceptives. And by the way, I don't think it's clear that there was a shifting ground, and certainly if you change your position based for litigation, then that's a pretext that will fail under RFRA. You can't just manufacture an objection. If they did shift, it would have been because they didn't realize they were covering things they objected to. I don't know, but I think that's not a clear point, if at all. But the objection of certain nonprofits is that not just to paying for the contraceptives, but even to signing a form saying, I object, and at that point the government takes it from there and either works with the insurer or does one of these other alternative things. And Little Sisters of the Poor, among other but not all religious nonprofits, have an objection even to that, because they think that makes them complicit in the sin as well, signing that form. And the answer there is, well, we'll litigate that out. Is there indeed still a less restrictive means than that, for example? The government could impose the mandate on insurers. Indeed, the government has said, and insurers have said, that it's cheaper for insurers to cover the emergency birth control than to cover the pregnancy and then the health care costs of the resultant child, in which case we shouldn't need mandates at all, and insurers should just give out Plan B on street corners, I suppose. And also, fundamentally, that exemption or accommodation wasn't offered to the for-profits, and so we don't know what their position was or would be. I think it's come out that even of the ones that we're litigating, I think Hobby Lobby, Jordan might correct me, but I think Hobby Lobby continues to object to that. I'm not sure about Conestoga. I mean, there's, again, you have to take, these are it's complex only because it's fact-specific. On the particular facts of Hobby Lobby, I found the statutory interpretation question exceedingly easy because the government could have made accommodations and exemptions like it did broadly for others. And you had a second question? I don't know if you...
Yeah. Oh.
Oh, transfusions, right. We're always outside, or should be, the government regulatory system. Our system is based on the idea of a sea of liberty with islands of authority, or the government can, being the referee, kind of policing the rules of the game and whatnot, but otherwise supposing to allow civil society to flourish. We've sort of lost this conception of the public sector that's not governmental. It's not just individual, what you do in the intimacy of your own home or in your own personal conscience or how you pray on your own time, and then everything else is public qua government, as opposed to public qua, public performance and public corporations, right, which are public because they solicit investors from the public, and civil society and of various kinds. And we have more and more government crowding out that public space, even if we say, oh, no, on your own time, you can read whatever you want, you can buy whatever you want, you can, pray to whoever you want, but just don't take that out into that public qua governmental space. And that's why the big difference here isn't the size of government in and of itself. I'm not just trying to have, a modernized diatribe of the libertarian complaint of, or the kind of the latest exegesis of the battle of, progressives versus retrograde laissez-faire or something like that. There's a difference between mandates and regulations versus taxes and spending. And so we can have a debate about whether the government should be spending taxpayer money on X, Y, and Z, and no one has taxpayer standing to challenge, that spending on defense or that spending on covering contraceptives or emergency contraceptives or abortions by public, in a court as opposed to in the legislature. But if you're mandating, if you're regulating, if you're in effect commandeering the private sector, whether individuals, corporations, companies, a bunch of buddies playing poker, or any other way in which people associate, that's a qualitatively different issue than talking about, should government be this size or that size? Should the income tax be 17 or 18%? Should we spend this? Should we expand this program that the government is providing? That's fundamentally what hobby lobbification is. This isn't about, government's too big. It's about government mandates being too big. And so, the more and more regulations, it's kind of like boiling the frog. At the beginning, maybe you don't notice because it's only, a few fringe elements that are affected, and everyone generally agrees. But you get to a certain point, more and more of our rights are implicated, and that's why the more and more the government mandates and regulates, the less legitimate its rule becomes.
Yes, sir. Please push your button and announce yourself.
Supreme Court thought it was compelling.
They assumed it was coming.
Okay, we can argue about whether it's truly compelling or not, but the argument is that access for many women depends on the financing of it, and if there is no financing, many women would not have access to the contraceptives, and that this is an important preventive, or that's the feeling of the Institute of Medicine and the CDC. This is an important preventive medical treatment, and there can be life-threatening consequences from pregnancy, in addition to the individual liberty involved in deciding whether or not you'll carry the pregnancy to term, and that making sure that there's equal access to this, not determined by financing, is a compelling interest. Well, Well, I think it gets to a broader public health question. Why should you pay for any preventive measure, for smoking cessation or for vaccination or for regular checkups or any of the rest? And I think if you're going to accept that that's a communal public responsibility, then the contraceptives are part of that class of medical interventions that we all benefit if everyone in society has access to.
Over here. That's not the reasoning of the Affordable Care Act. The reasoning of the Affordable Care Act is that we've an interest in providing preventive care without cost, because people won't have medical conditions later on. We'll all save money. People will be healthier and presumably better for it. And there has been a decision made to put contraceptives in with other preventive treatments. So the reason that it's included in the Affordable Care Act is not freedom of procreation, individual liberty with regard to your body. It's the interest in promoting preventive care. You can argue whether this is preventive care
to the same extent that an annual checkup is, but that's the argument for why it should be there, not the individual liberty argument.
There's a question over here. No? Anything else? All right. Please join me in thanking our panelists.
Thank you.